the Mandlanga Commission of Inquiry adjourned yesterday to recommence on the 13th of October. This is following a current witness, Crime Intelligence Head General Dumisani Khumalo, falling ill. A broader question has arisen around the truncated timelines and whether such unforeseen events would not impact the finalisation of the commission. We're joined by Advocate Carol Steinberg, who was evidence leader in the Nugent Commission, to give insights on the administrative aspects of a commission that ordinary citizens would not necessarily have an appreciation of. Good afternoon, Advocate. Thank you very much for joining us on the programme. Now, this commission specifically... Good afternoon. Now, this commission specifically seems to enjoy a great audience. So the adjournment after General Khumalo took ill has sparked greater interest around the managing of such an important inquiry, more specifically how such unforeseen events such as illnesses impact an inquiry. How are they generally managed?
Well, there's not much one can do about human illness and other issues that crop up. And depending on the nature of the evidence that the witness is giving, it might be difficult to interrupt that evidence and begin something else. It might be necessary to finish that evidence first. I'm not sure in this case. I guess one way of anticipating these problems is to have other witnesses prepared to step up if this kind of thing happens. But as I say, the commissioners would have to decide whether that's fair and makes sense in each instance.
But one assumes there would generally be a set sequence on the witnesses to be called, and one would assume that in this instance that perhaps to interrupt would lead to some sort of a disjointed testimony, maybe even for the audience back at home, that now you've interrupted this specific witness to start with somebody else only to come back, and it perhaps might not have the same impact where people still remember where exactly that specific witness might have been. Are those things taken into consideration? Because with such an inquiry, it's an open process even for the benefit of people at home. So in as much as you as evidence leaders would know exactly where that witness ended and you would know what preceded, people at home might not still recollect. So does it matter, or is it taken into account that this is a process even for citizens' benefit? So most certainly you wouldn't want to then jump onto another witness.
You're quite right. One of any commission's aims is to inform the public and to hold people accountable in front of the public. And that does have to be taken into account. At the same time, there are other priorities which have to be considered. There's fairness to the witnesses involved and what any impact on that might be, for example. And there is the need for expedition. The country knows that it's important that this does not drag on and on for a couple of years. So those factors all have to be balanced against one another. There are ways of dealing with interruptions. For example, the evidence leader could summarize the evidence that was given up until the moment of the interruption and then carry on. These are all, unlike a court of law, a commission does not have strict rules that govern it. It's an inquisitorial process. It's there to find the facts in the best and quickest possible way. And unlike in a court, it doesn't have to first hear the one side and then hear the other side. It can choose the way it runs its processes from beginning to end, as long as they're fair.
Then to those leading the evidence, one assumes that they would act dispassionately, that they are just discharging their duty here and just assisting the witness because they would have prepared them and taking them through their testimony. But sometimes you find in society those that assume that now the evidence leader perhaps is one that has bought into the version of the individual that they're leading. Can you share with us exactly where the line is drawn between the evidence leader and the witness before them? Because they do assist them and sometimes summarize for them. Some people might say you're putting words into the witness's mouth. Just share with us exactly the position of those leading evidence.
Again, very important to distinguish commissions of inquiry from courts.
Yeah.
When an advocate leads a witness in evidence in court, the rules of leading a witness are that you have got to let the witness tell their own story. When it's your own witness, you can't put words into the witness's mouth. You can't ask leading questions. Those would be disqualified. When you're cross-examining the other side's witnesses, you're obviously trying to trip them up. Now, those are not the rules in an inquisitorial process. The rules, again, they are flexible. In the Nugent Commission, we chose to neither be leading nor cross-examining, but to have enough information before us to both let the witness tell his or her story, but at the same time to challenge something that might not be credible because we have evidence to refute it or because it doesn't sound credible, to draw attention to where that witness doesn't have evidence backing up their say-so. Mm-hmm. So again, it's up to that commission to decide how the evidence leaders should conduct should conduct their evidence. The little bit I've watched, I've seen different styles. Yeah. With regard to Lieutenant General Mkhunazi himself, there it was very much like a court process of a witness being led without really being challenged in any way. Yeah. Some of the later witnesses I saw actually were challenged. More difficult questions were put to them. In my own view, it's more effective to put the difficult questions to the witness as they're testifying because it saves time. Mm-hmm. You don't have to call them back and put the difficult questions at another time. Now, and you don't leave the public with a possibly false impression that everything that person has said is true and supported by evidence.
Now, Advocate Terry Motau has broken his silence on the reasons for his withdrawal from the Commission. It's quite the big story today because many have been wondering what exactly this all means for the Commission, given the timeline, strict timelines at that, but also the reasons behind that specific withdrawal. And among the things that he has stated is around the budget, saying that if you have 147 million that has been allocated to a commission, you have to take into account line items, that you must have line items that this is for the senior counsel, this is for researchers, etc. And in as much as he wasn't particularly clear as to the reasons, but he went on to state that really you can have a situation if you don't budget enough. You can have a situation similar to the State Capture Commission, where you had advocates who were working for 2 months not getting paid in the last stretch of that inquiry, where for 2 months they were not paid. So it seems there are always budgetary concerns around a commission. And he went on to state that something as simple as consultation with a witness, that if General Mkhunazi is going to be consulted, is it the junior that consults and then puts together the first draft, or should the junior and the senior counsel sit in on that first consultation? Because all of that has cost implications. Just share with us the issues that could plague a commission when it comes to budgets.
It's very hard for me to comment on these issues because I simply am not an insider. I don't know the specifics. It's obviously very important that the Commission budgets carefully and accounts for every cent of public money. I can't say whether that's been done or hasn't been done. Mm-hmm. The commissioners are honourable and competent people. And there's nothing I can say about Terry Motau, who is also an honourable and competent person. I just have no insight.
Mm-hmm. But as an evidence leader who perhaps would have to manage a team and bring on board perhaps experts, if perhaps you would have taken a pay cut, that is a duty and a choice that you make. But should citizens always remember that it's not everybody, perhaps even a junior, that must then take a pay cut? As the evidence leader, you would still have to advocate for them, that if we're bringing specialists on board, then they must be paid their share. So it becomes difficult in that position where they're looking to you to negotiate on their behalf to ensure that they have their salaries.
I think, certainly to my knowledge, all counsel who work on commissions work at a lower rate than they would do in their ordinary practice. And it's an act of public service, and it's also a great honor to serve on these important commissions. So I think that is the starting point, that all advocates generally agree to work for less than they would work for in their practice. And there's no doubt that a junior advocate or anyone else who's giving up their time is entitled to be paid a reasonable amount during that time. It's not just the more senior people involved. And the budget has to be very carefully allocated to be fair and sufficient.
All right. Advocate, thank you very much for your time.